Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law for which Honorable High Court of AP asked the DGP to circulate the case of Lalitha KUMARI versus Govt. of UP 2013 case to all the police officers to read the judgment and follow it in letter and spirit. This has come in order. Justice PV Jyotirmayi, while dealing with the case of K. Rama Rao Visakhapatnam versus State of Andhra Pradesh and another case in another writ petition, she has given the above instructions. We all know that Madam Jyotirmayi, she was first selected as a magistrate, worked at Ungol. Then as a district judge, also she worked at Ungol, and she is thorough in law. Apart from that, let us come to the point straight. This Rama Rao, K. Rama Rao, he is from Visakhapatnam. He went to Maharanipeta police station, or we can call it as one town police station, to report an incident, to give complaint regarding a cognizable offence, but it was not registered. Okay. Then another incident also came to the notice of the court where the police did not register the FIR. And the advocate on behalf of Mr. Rama Rao by name PV Jyotirmayi, he has cited so many judgments. Convinced with the judgments, now the Honorable High Court Justice PV Jyotirmayi stated that, observed that police are not registering cases, that too cognizable offences. They have to be sensitized. Therefore, she directed all the DGPs to send the Telugu copy, translated copy of Lalitha KUMARI judgment. See that they followed, right? Why Telugu means all the people should understand. Of course, you know that Supreme Court judgments, now they are being translated into Telugu regional languages also, thanks to our former CJI Shri N.V. Ramana. Now, important point is, what is this Lalitha KUMARI case? This is more important. Lalitha KUMARI versus Govt. of UP 2013. Very famous case. I can say it's ill-famous case. But Lalitha KUMARI judgment, everybody should know, whenever any topic of FIR comes, Lalitha KUMARI judgment will come into play. So, there are slew of directions given by the Honorable Supreme Court of India in this particular case. Actually, we have to pay obeisance, or we have to congratulate the father of Lalitha KUMARI. By name, I think he is Kamal Bharot, or I think. It's a judgment given by the Constitution bench, 5 judges bench, under the head of the then Chief Justice P. Sadashivam. Right? On 11/5/2008, Mr. Bhanot, he went to the concerned police station in UP. He has given a written complaint to the officer in charge of the police station, but no action. Later, at the instance of the Superintendent of Police, 154 Class 3 CRPC, the case was registered, but no steps were taken for apprehending the accused or for recovery of the gun. So, Justice P. Sadashivam, Chief Justice, B.S. Chauhan, Ranjana Prakash Desai, Ranjan Gogoi, and S.D. Bobde. Very, very few. All of them retired as, most of them retired as CJIs. Right? So, the important point is whether police officer is bound to register the FIR. In all cases, this is the important point. Yes, they have to register. As per 154 CRPC, whenever any cognizable offence is reported in the police station, it is the bounden duty of the police to register the case. Right. But there are instances where whether the cognizable offence, the doubt may be entertained by the police, whether this is a case, whether this is a cognizable case or not. In such cases, what they have to do? They have to conduct the preliminary inquiry. This is more important. So, definitely it is mandatory to register an FIR under 154 CRPC. If preliminary inquiry is necessary, please remember, definitely they can take some time, but they should be only within 7 days, and they have to take any one step, either register the case or inform the complainant that it is not a cognizable case. But in some cases, they can conduct the preliminary inquiry, like they are matrimonial disputes or family disputes. Matrimonial disputes, why? A wife comes to the police station and says, "Sir, na husband illa cheyandi, don't register case, but see that you are united." For that purpose only counseling is done. In such a cases, instead of registering case and separating them, better to wait for better to conduct the so-called preliminary inquiry. Matrimonial disputes or family disputes. Number 2, commercial offences. Commercial offences involve crores of rupees. Lot of investigation is necessary. Lot of documentation is necessary. Lot of collection of the documents is necessary. Therefore, whether it comes under this or whether arbitration can be allowed, all these things. For this, they can conduct the preliminary inquiry. Third one, corruption cases. You all know, in Chandrababu Naidu case, we are dealing with the headache, the problem of 17A. So, whether the permission is necessary or not, so some preliminary inquiry, yes, definitely the ACB people, they will conduct the preliminary inquiry. After satisfying only, they will proceed further. Then, cases where medical negligence cases. You all know the very famous case of State of Punjab, Jacob Matthew versus State of Punjab. Unnecessarily, medical negligence cases should not be registered. You have to take the opinion from the senior civil surgeon. Then cases where there is abnormal delay in initiating criminal prosecution. No doubt. So, there is a provision. Even 462 CRP says there is a limitation. But sometimes there will be abnormal delay. If delay is there, collection of documentation will be very, very difficult. In such cases, you can conduct the preliminary inquiry. So these are only illustrative but not exhaustive. Please remember, just examples we have given. So the completion of preliminary inquiry should be within 7 days. In the meantime, you have to inform the complainant as to what happened. So these are the important things. So please read the judgment. Of course, Telugu is the judgment may come 1 or 2 days. I can't speak that Telugu that fluently. So therefore, please read the judgment. So Kabut, ultimately she has given the actually leverage or exception to the complainant to follow the procedures. So you know that there are 3 procedures. 1, 154 CRPC. Cognizable case, police have to register. If it doesn't register, then 154 class 3 CRPC, that you have to approach the superintendent of police. Third one, you can file a private complaint under 156 and it will be endorsed to the concerned police, 156 class 3. These are the methods of filing the FIR. So the plaintiff or the complainant, the writ petitioner can choose any of the forum. So why I have made this video is to apprise you about the Lalitha KUMARI case, which is a very, very important case. Even though Lalitha KUMARI, now she is the deceased, her father, he has filed the case in the name of Lalitha KUMARI. So please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.